Hello friends, in July of 2023 there was some big changes to the Florida parenting plan and time sharing statute that has had huge ramifications in dissolution of marriage cases that involve children. So today we're going to go over some of the big changes that were implemented by the Florida statute. Welcome back to the Divorce Broadcast. My name is Manny Segarra, coming to you from Miami, Florida. All right, Florida Statute 61.13 discusses the support of children as well as parenting plans and time sharing schedules. In the summer of 2023, specifically in July, the legislature of Florida passed some sweeping changes to the alimony law, which we had a video on before, as well as to the statute that governs time sharing or parenting plans for children. So let's go over those big changes now. One of the first changes that appears in the amended Florida Statute 61.13 is the section that has to do with mental health treatment of children. The latest rendition of the statute in 2022 allowed for either parent to consent to the mental health treatment of children. It is similar in 2023, however, there's a little bit of a tweak in the language. The language specifically says that either parent may consent to the mental health treatment of the child. And here's where the change is: unless stated otherwise in the parenting plan. Well, that was a little bit of a modification of the previous language of the statute. However, the most sweeping and biggest change of Florida Statute 61.13, which governs parenting plan and time sharing schedules, is that now there is a rebuttable presumption of equal time sharing. Whoa, that's huge news. Now, before I get into that, I would be remiss if we didn't talk about back in the 80s and 90s, perhaps growing up in the 2000s and the early 2000s, it used to be that one parent would usually just have alternating weekends and maybe one day a week time sharing, or it used to be called visitation back then. Usually, and I'm not saying each time, but usually it was the dads who would have every other weekend and once a week. The rest of the time, the mom would have the children. However, based upon this new change in 2023, there's a rebuttable presumption of equal time sharing. If you read it, the statute says in particular part, unless otherwise provided in the section or agreed to by the parties, meaning unless it's otherwise provided, there are some exceptions, there is a rebuttable presumption that equal time sharing of the minor child is in the minor child's best interest. As you sit there and now you go to court on a divorce case, if there's children involved, the presumption is it's equal time sharing for either parent. That is probably the biggest change in the time sharing statute. The statute regarding time sharing goes on to say that to rebut the presumption, meaning the presumption of equal time sharing, a party must prove by a preponderance of evidence that equal time sharing is not in the best interest of the minor child. So that is huge. Some examples may include perhaps a parent suffers from some sort of substance abuse issue. Maybe there is a domestic violence component to the case. Maybe one of the parents suffers from a mental health disorder. One of the other areas in which this may be viable is if there is a geographic distance. If there's a large distance between the parents, so that one of the parents may not live close to the minor child's school, therefore an equal time sharing schedule would not work out. These are just some examples of when maybe the presumption of equal time sharing can get overcome. But remember, as you're coming into court, the court is presuming that it's an equal time sharing schedule, except when the parties actually come into an agreement that is approved by the court must evaluate all of the factors set forth in 61.13 subsection 3. We're going to do another video on that particular subsection to see what's in the best interest of the child. But either way, remember that the prism by which the court is looking at the case involving children has changed. It is no longer your granddaddy or your daddy's divorce. These divorce cases, if they involve children, the presumption is equal time sharing. Another change that is pretty significant is that the previous statute 61.13 from prior years, it required that the court order parental responsibility for a minor child to be shared by the parties. Now, just a quick explanation. Remember that parental responsibility or shared parental responsibility means decision making. Who gets input as to where the child will be registered in school, who gets to select the medical or dental appointments, who gets input or say as to religious indoctrination, or any other special parenting decisions that are specific to the particular family. So the statute reads that the court shall order parental responsibility for the minor child to be shared by both parents unless the court finds that shared parental responsibility would be detrimental to the child. Now here's where it gets a little bit interesting. In the previous statute, the court or the statute laid out what would cause there to be a rebuttable presumption of detriment. And that was laid out as either some sort of domestic violence conviction, some sort of issue regarding child abuse or child neglect. It talked about some of the more serious crimes like sexual battery and things involving like sexual predators. But it gave a list of particular crimes that if you're convicted of, you will no longer be allowed to have shared parental responsibility. That particular portion of the statute has changed slightly. What the new statute does is that it keeps that part. It keeps the cases that will create a rebuttable presumption of detriment to the child, but it adds another layer right before that, where it states specifically, in determining detriment to the child, the court shall consider, and then it says evidence of domestic violence. It doesn't say conviction, so that is completely different. And then another section says whether either parent has or has had reasonable cause to believe that he or she or the children are in imminent danger of becoming victims of domestic violence. So this kind of traces the language of the injunction statute, which is the domestic violence injunction statute. And then the third one that is added is whether either parent has reasonable cause to believe that his or her minor child or children have been in imminent danger of becoming victims of an act of, and then it lists all of the child abuse and child neglect statutes. So that is a little bit different than what we had before. Because what we had before is it said shared parental responsibility unless it's detrimental to the child, and then it went specifically into what cases are automatically assumed to be detrimental to the children or to the child. What it does now is, before we get to that part, oh, by the way, you can consider any evidence of domestic violence, any evidence that you fear of imminent harm or fear that they would imminently become a victim of domestic violence, and fear that the child or the children involved in the case had an imminent fear of becoming victims of some sort of child abuse, child neglect, and that type of cases. And finally, we're going to go over the last part of the time sharing and parenting plan statute, 61.13, that was revised or amended by the Florida legislature. And that is that it changed some of the language as to how a parent can modify a time sharing schedule. Whereas before, the only way that a modification of a parenting plan could take place is if the other parent showed a substantial, material, and unanticipated change in circumstances. What the legislature did now is they got rid of the unanticipated portion of it. That is huge. One of the ways that a lot of attorneys try to defend whenever there's a modification proceeding is that they say that it wasn't unanticipated. Well, now it doesn't have to be unanticipated. So let me give you an example. If a child is young when the parties get divorced, and after they get divorced, it becomes known that the child is on the autism spectrum, clearly this is a change in circumstances, and it was unanticipated at the time that the divorce happened, because it's something that happened post or after the divorce. That would allow for perhaps a modification of the time sharing schedule to address the needs of this special needs child. However, let's say that the child had or was on the autism spectrum at the time of the dissolution of marriage under the old statute. That would not be cause to change or modify the schedule, because if the child was autistic before and the child is autistic now, but perhaps their condition has gotten worse, or perhaps the condition has gotten better, if that other parent wants to change the time sharing schedule, they wouldn't be able to do it before because it's something that was already occurring. So it wasn't unanticipated. So given the new statute, you don't need to have an unanticipated change. So that is a little bit of a shift in the Florida time sharing and parenting plan statute. Additionally, they also put a provision in the new statute or the revised statute that I really like. Specifically, it involves parents who are on a long distance parenting plan. So if there's a divorce and one parent lives in Florida the other parent lives in my home state in Illinois, and that other parent now moves to Florida, well, this statute contemplates that particular scenario. Specifically, the new version of Florida Statute 61.13 says if the parents of a child were residing greater than 50 miles apart at the time of the entry of the last order or the final judgment establishing timesharing, and a parent moves within 50 miles of the other parent, then the move may be considered a substantial and material change in circumstances for the purpose of modification of the timesharing schedule, so long as there is a determination that the modification is the best interest of the child. That is something new here in Florida. A lot of times, given the mobility of this country, that has occurred. We have dealt with that type of cases often at this law firm, and just simply putting that or removing that impediment where a parent, now that they've decided they want to live closer to their child, now they have the relief that they're looking for, which is they can now change the schedule. It not only makes a lot of sense, but it's very practical, because now parents, if they want to get involved in their children's lives and they move closer to each other, they're going to be able to change their schedule. So I really like that amendment. Good job, Florida legislature, making that particular provision. All right, so that is a wrap on our discussion of the updated Florida Statute 61.13 that addresses parenting plans and time-sharing schedules. There's some big stuff here. Remember, especially when it comes to the presumption of the equal time-sharing schedule, the deletion of the unanticipated change in circumstances, and then the geographical 50 miles if you move within 50 miles of your children and you were outside of that distance before. So there's some good stuff in the statute. If you know anyone that may benefit from this information, have them look us up at www.segarralawfirm.com. We have offices in Miami and Orlando, Florida. Se habla español. Do us a favor, hit the like button on this video and subscribe to the Divorce Broadcast. We'll talk to you soon. Thank you.